It's 19 days until Christmas Day, and let me be honest, less than 2 weeks until JFJ closes and we can get a little Christmas rest. So I'm making that very, very clear that I'm a Christmas person. And when December 1 hit, I think I've been counting down Christmas actually from October. But again, we're trying to have a little decorum and we love the justice work and so on, but we need our rest, yes?
Yes.
But we are in the festive season. My name is Michael Jackson, Executive Director of Jamaicans for Justice.
And I'm Jade Williams, Policy and Advocacy Specialist at Jamaicans for Justice.
So my excitement is not just because we're counting down to the Christmas holidays and we can get some rest with our phones off. My excitement is also because in the human rights space, outside of public advocacy, when you take a step back and celebrate how far communities have come, it is something, again, to be celebrated, to acknowledge. So, for example, December 1 was World AIDS Day, and we celebrated that day under the banner, Let Communities Lead. We went to several events by our partner agencies, Jamaican Network of Seropositive Jane Plus, Jamaica AIDS Support for Life. Great events were held, and you saw the advancement that we have made in the HIV response. You saw us overcoming stigma, and yes, it still remains in the country, but it has far reduced. And again, it's something to be lauded. You hear the success stories of people living with HIV, getting master's degree, recognizing again and living their true potential. Again, much to be celebrated. So big up to our partner agencies in the HIV response. You showed up, you came out, and the communities also demonstrated improvement. So as we talk about human rights, recap of the week, that is the first thing I want us to touch on, Jade. Yeah. Last week as well, we also did our open letter. We submitted to Parliament, so we hope that there is some acknowledgement from the parliamentarians, and that open letter was calling for, yet again, for some legislative changes to be made to the Domestic Violence Act and other related pieces of legislation when you talk about sexual violence, the Sexual Offences Act, the Offences Against the Persons Act, and the Child Care and Protection Act. We have been waiting far too long. In the letter, we noted that the first Joint Select Committee reviewing these pieces of legislation, they first met in 2014.
Yes.
It was stalled. Civil society, we were on the ball. We were calling for it to be reconvened in 2016, 2017, early 2018. The sitting of the Joint Select Committee, newly established in 2018, they met several times. A report culminated in December 2018, yes, released in 2019, and it's now 2023 December. And not one of those recommendations has been fulfilled. Not one. So we acknowledge the Sexual Harassment Act in our letter, but in terms of the recommendations dealing with redefining rape, decriminalizing abortion, nothing has been done.
Removal of marital rape, another very important one. Nothing has been done. So we certainly hope to see that acknowledgement coming and some commitment to actually implementing these proposed changes. And these are proposals that the Parliament already accepted. So,
and put it, well, with the exception of redefining rape, yes, lack of political will there. But put it this way, even if they don't acknowledge it, let me tell you, come 2024, civil society will be demanding that they do. So not to push the work ahead for next year, but it's something that we must remain on top of the game in terms of recognizing the importance of these things, how it affects marginalized population, poor and vulnerable women. So we continue. And another thing, Jade listeners, for us to touch on, yesterday, Freedom Imaginaries, headed by its founder, Melanie Elaine, she launched a campaign, hashtag with Haitian migrants. A virtual press conference was held, and it had the support of Human Rights Watch, Stand Up for Jamaica, Advocates Network, and of course Jamaican for Justice, calling for greater response from the Jamaican government in adhering to rule of law, but also a regional and international response in responding to asylum requests from those who are running away from what is happening in Haiti, that's civil and political unrest. Very good press conference, and I think JFJ, we stand in solidarity with Freedom Imaginaries on this journey. I think, let us put in context that since July of this year, we have had 120 Haitian migrants coming to our shores. 80 of them have been returned. And I want you to think about an attorney going to where the Haitian migrants are, going to the police station in Portland, for example, being denied access, being intimidated by law enforcement. In the middle of the night to early morning, she's driving down a police vehicle who is taking the Haitian migrants to an undisclosed location to return them to Haiti. It's unacceptable. I want to also put in context that despite an asylum request being made, the government has ignored Maleni. Despite a precautionary measure request being made to the Inter-American Commission on Human Rights, they have ignored it. For Jamaican citizens listening on, the precautionary measures in this context also has implications for us. So, for example, JFJ, we have requested it before, where when the government is violating any of our human rights, we go to the IACHR if they ignore us. And the IACHR would say to the government of Jamaica, hold on, take a step back. I suggest that you do X, Y, and Z in respecting the human rights of this particular citizen or community. I recommend compensation. When the government can ignore a precautionary measure that is currently under review, scant regard for rule of law, scant regard for our regional bodies that exist to protect us. So a cautionary tale there. But I just want that for food for thought. All right, over to you, Jane.
Thank you so much, Mikel. We'll go straight into our right of the day and our trivia question for this week. Our right of the day comes from our Charter of Fundamental Rights and Freedoms, and it relates to your right. Well, commonly it's called double jeopardy. But this is the right that prevents you from being tried for an offense for which you have already been convicted or acquitted. So if you have gone to court and your case has concluded with either a conviction or an acquittal, you cannot be tried for that offense again unless it is that the proceedings that we're talking about are appeal proceedings, in which case it's not necessarily a trial. You are re-examining some of the points from the original case. So once you have been tried, you cannot be tried again, and that is Section 16(9) of your Constitution, and it makes up a part of your right to due process. And our trivia question for today is in keeping with our topic, and it asks, on what date did the agreement that established the Caribbean Court of Justice come into force? And so we'll take your answers via WhatsApp or Instagram, and you know the WhatsApp number is 239-7583.
All right. Thank you so much. By the way, I knew of that right because I watched Ashley Judd's movie.
I knew you were going to say that. I knew you were going to say that.
As a child. just letting you know, and of course, John Grisham fan.
Yes.
But, yes. Movie pricky, as you would say. But back to serious business, we're going to be discussing an important topic, one of which is on the constitutional reform agenda, and that is the Caribbean Court of Justice. We're going to be examining what we mean by decolonization, and of course looking at the regional jurisprudence and the importance of the CCJ. We are most honored that the person leading on that discussion with us today is no other than the Honorable Mr. Justice Adrian Saunders, who is the president of the Caribbean Court of Justice. It's a big deal having Justice Saunders with us on the program, and he will join us in a few minutes. But just to do a little bit of intro before Justice Saunders joins us, we have had 5 Caribbean countries adopting the Caribbean Court of Justice to date. And those countries include Barbados, Belize, Dominica, Guyana, St. Lucia. We saw where St. Vincent had put it to a referendum, and that, of course, did not go through. The CCJ remains a political divided issue here in Jamaica, with some members of the public and so on questioning the court's credibility, its independence, and the psychological attachment to the familiarity of the Privy Council. Others have made some unfounded comments about whether or not people went to law school together and therefore friend and friend thing and so on. Some people believe that the Privy Council rulings have been a little bit more sound than the CCJs, and that is one of the justification for us remaining with the CCJ. So we're going to be looking at whether or not we should reinforce regional integration and sovereignty when we talk about the broader CARICOM, and whether or not we should be talking about the retention of ties with the Privy Council based on the perceived advantages in legal expertise and tradition.
Now, we've been trying, there has been some effort to promote the adoption of the CCJ as a symbol of regional autonomy and as a manifestation of Caribbean unity, which is originally how it was intended. And our journey as Jamaicans to embracing the CCJ has quite a few obstacles, as Mikhail would have alluded to. And the decision to sever ties with the Privy Council is not simply a legal issue. It is definitely one of a historical and cultural framework that we have to examine. So overcoming these challenges will require a delicate balance between honoring the past and going towards a more independent future. So when we return from the break, we'll be joined by Mr. Justice Saunders, and we'll be discussing this issue.
Good afternoon and welcome back to Let's Start Justice. We are talking on an important topic, the Caribbean Court of Justice, one that I'm sure will be on the agenda for many, based on the fact that we have established a constitutional reform committee in the island looking at, becoming a republic and what that republic status would look like. We have had conversations happening in the country where the parliamentary opposition, for example, have indicated that they will not support Jamaica becoming a republic unless and until we also adopt the Caribbean Court of Justice. The Jamaica Bar Association have also lent their voice to this particular issue. And for the avoidance of doubt, where Jamaicans for Justice stance is, we support Jamaica adopting the Caribbean Court of Justice. So I wanted us to start out from that perspective. We are having this discussion, and again, I stated that we are most honored that we're joined by the Honorable Mr. Justice Adrian Saunders, who is the President of the Caribbean Court of Justice. Justice Saunders?
Good afternoon to you, and I certainly appreciate having been invited to share some views on the Caribbean Court of Justice, give some information rather.
Yes. I wish you were here with us in person, but we appreciate you joining us via Zoom, of course. Now, Justice Saunders, if we could just start out with you explaining to the listeners the jurisdiction of the CCJ in terms of the final Court of Appeal and, of course, within the context of the Treaty of Chaguaramas.
Okay, so thank you again. The Caribbean Court of Justice was set up by the heads of government of the Caribbean community with two broad areas of work. One, we interpret and we apply the revised Treaty of Chaguaramas. That is the agreement among CARICOM member states that establishes the CARICOM single market and economy. If there is a dispute, whether among states or between the Caribbean community and a state, or between an individual or a company and the state, and one side wishes to bring that dispute to a court for resolution, then they can bring that dispute to the Caribbean Court of Justice, and the CCJ has exclusive, call it jurisdiction, authority to give an answer to that dispute. You get the answer, you have no appeal. Caribbean Court of Justice is the first and last court in that sense. What Jamaica is currently consumed with is not so much the CCJ in that area of its work. It is more the CCJ in the second area of its work, which is to be a court of appeal to replace the Judicial Committee, the Privy Council, for those that still send their appeals to the Privy Council, or in the case of Guyana, that stopped sending their appeals to the Privy Council since 1970 to be the final court of appeal for that country.
Thank you, Justice Saunders. And for those who are listening on who may not understand the concept of regional integration fully and CARICOM, it touches on issues of free mobility among and between CARICOM member states. So I think one of the most notable cases that Jamaicans can recall is perhaps the Shanique Mary case that was represented by Nancy Anderson some years ago that involved Barbados.
That's correct. Yes. And this was a case where an ordinary Jamaican young lady wanted to spend some a vacation in Barbados, and she was treated very badly by the border officials and sent back the following day. And she complained to the Caribbean Court of Justice, and the CCJ found in her favor, and it gave a judgment that the state of Barbados complied with. And I'm sure that she and her lawyers were very satisfied with the result that they received.
Yes. As you said, Justice Saunders, it's a, I don't know if contentious is the issue in Jamaica, but we're divided on the issue here. And just recently, a letter was written to our main newspaper, the Jamaica Gleaner, from Lord Reid of the Privy Council, where he sought to clarify and maybe dispel some of the assertions that have been made in terms of access to the Privy Council. So, for example, and I'll just read a section of the letter if you have not yet had a chance to look at it, Justice Saunders. But what Lord Reid said was, your editorial, which is the Jamaica Gleaner, had written an article before. Your editorial also mentions the difficulty and expense of having to travel to London for hearings. I would like to convey to our readers that the court is not as remote or inaccessible as they may have imagined. For example, we have hearings online so that lawyers can address us from their offices in Jamaica. And then Lord Reid also suggested that the concerns that we have had that Privy Council want to do away with countries such as Jamaica is certainly not true. So I'm not sure if you could put in context, Justice Saunders, some of the broader justifications that have been made as a reason for Jamaicans looking on to say, let's adopt the CCJ. What are the concerns with the Privy Council?
Okay, I want to make 2 points. The first is that this interview was actually arranged, as you know.
Yes.
Before that intervention by Lord Reid.
Yes.
The second point I want to make is that I know Robert Reid. He and I were on a panel together just 2 months ago in Cardiff. He was the chair, I was a panelist. And I have no doubt he's a fine, upstanding gentleman, and I'm not here to respond to him. But I want to talk about the role of an apex court. We call the Final Court of Appeal apex because it's at the top of the court structure.
Yes.
Apex courts do not exist simply to receive filings, to hear from lawyers about the dispute on which they have filed their cases, to give a judgment and to publish that judgment. That is not the full breadth of what an apex court does. Apex courts that are worth their salt, apex courts that operate in all countries, are supposed to be at the pinnacle of the judicial system.
Yes.
They're supposed to engage in assisting the administration of justice as a whole. They play a fundamental role, for example, in judicial education. So, for example, in the United States of America, the Chief Justice is the head of the federal judicial branch.
Yes.
And that is a branch that engages in research and education. Similarly, in Canada, the Canadian Chief Justice, who is the presiding judge of their apex court, she is the head of Canadian Judicial Council. So one of the difficulties, one of the deficiencies with Jamaica's current system is that it does not have an apex court that plays this role.
Yes.
It has an apex court which simply receives a dispute and gives out a decision.
Yes.
And that was good enough when we didn't have our own court. But now that we have our own court, then you would want to ask whether that is sufficient. Some of the things that I've found missing or insufficiently addressed in what I have seen in the press, in the robust debate, and I really very much enjoy the debate that is taking place, because it is important
Yes.
that people discuss and get an understanding of all the various ramifications and the considerations, and more importantly, that they have an opportunity to understand what the facts are. One of the things that I find that is missing is that we don't sufficiently appreciate why you need an apex court. What is the role of an apex court? An apex court is not there simply for those who are well-heeled, who are affluent, who can access it. An apex court is there to resolve the hard cases.
Yes.
In your court structure, you have magistrates, but in Jamaica you call them now parish judges,
Yes.
which is really great. You have trial judges, you have appellate judges, judges of the Court of Appeal. When you have a matter, you go to the magistrate or you go to the judge and you try your matter. The judge decides on the matter. One side might be dissatisfied. They might figure the judge has made a mistake. You go to the Court of Appeal, and the role of the Court of Appeal is to decide whether the judge has made a mistake. And normally that is it.
Yes.
Yes.
But sometimes you have instances where the law is uncertain, where two or more reasonable minds can come to different views on what the law is, or situations where the law is out of keeping, out of step with what the society requires. And in cases like that, you go to an apex court.
Yes.
So apex courts have fewer cases, but they have the hard cases. They have those cases where the law needs to be clarified. When you have a situation where ordinary people, by reason of high filing fees, by reason of all sorts of barriers, are unable to access an apex court, then your jurisprudence can get undermined, stultified, because the hard cases, it's not only rich people have hard cases.
Yes.
All of the hard cases we have done, 99% of them have been brought by ordinary poor people. We have done, for example, cases where a single mother who wanted a protection order made against the father of her child was not able to get that from the courts below.
Yes.
She appealed to the CCJ, and we were able to clarify the law in relation to single mothers, because there was some uncertainty in the law as to whether the only persons who could apply for protection orders were spouses and former spouses. But the law was written in such a way that former spouses included persons who were in visiting relationships, persons who were in cohabitational relationships. So I'm going on and on.
You're being very clear, Justice.
The point I'm making is that any country all the countries of the Caribbean, they require an apex court that can address all the hard cases, the cases which help to carry forward and develop, promote their jurisprudence. We have done cases where, and this is another very important role of an apex court, the dialogue that court carries on with the other branches of the government.
Yes.
Constitutionally, the state governance in the country is dispersed among three branches: the parliament, the executive, we could call it government,
Yes.
and the judiciary. These are three co-equal branches. In a healthy democracy, there is a certain interplay between and among these branches. Not that they sit down at a cocktail party and discuss things. No. In the carrying out of their roles, they influence each other and they accept intimations or sometimes directions from each other. And so, for example, we've had several judgments where, as a result of our judgment, Guyana, the state of Guyana, the Parliament of Guyana, has decided that they need to change their law
Yes.
because of what the CCJ has said. We have had judgments where, even when there has been a dissenting opinion at the CCJ, the government of Belize has said, we prefer that dissenting opinion, and so we are going to alter our law in order for it to conform to that dissenting opinion. We've had cases in Barbados where the Parliament of Barbados has decided, after one of our judgments, that we need to amend our constitution. And they have.
Yes.
So there must be this dialogue that takes place. And this is something that occurs in apex courts in the United States, in Canada, throughout the Commonwealth world. And it's not just about, carrying up a case by those who can afford to and getting a result.
Yes. Without asking you, and I'm not asking you to comment on this, Justice Saunders, but just putting in context some issues for our listeners as you were going through some of those jurisprudential issues, that even some of the ongoing matters that are happening in the Jamaican landscape now, we just, for example, it's now actually law, the Bail Act, that has some controversial matters such as pre-charge detention. We saw, for example, this routine use of state of public emergency. And from JFJ's standpoint, we do believe that it's not adhering to the constitutional provisions that exist. So there are several ongoing matters in our country. For example, again, the savings law clauses and the importance of us challenging those. We saw the Maurice Tomlinson matter going before the Privy Council recently. So those are some of the matters, Justice Saunders and listeners, that we have, even within the Jamaican landscape, that the question itself arises. If we were to challenge some of these issues at the Privy Council, what would be the implications for our constitutional provisions versus what the CCJ may say? So we're going to take the break, Justice Saunders, and ask you to pick up on, what are some of the notable cases that we have had within the CCJ. I know Jade has some questions on that to put forward that you could say may have shifted the jurisprudence for us here in the Caribbean region and what Jamaicans can look forward to. So we take the break, Justice Saunders, and then we return with some of those questions.
Welcome back to Let's Talk Justice. We are discussing the Caribbean Court of Justice and adaptation, its current operation, several things, and we are honored to be joined by the Honorable Mr. Justice Saunders, President of the Caribbean Court of Justice. Justice Saunders, before the break, we were hoping for you to shed some light for us on some of those influential matters that the court would have heard that has affected regional jurisprudence, and coming off of the back of our own experience with our current apex court and the lack of, and I'm really trying to choose my words carefully here, but the lack of significant controversial decisions. We found in our experience with the Privy Council that they tend to stick with what our governments and our parliaments have decided in our legislation rather than looking at where it could be challenged. So we wanted to know what, if any, cases from the CCJ's jurisprudence would have had some influence in the countries.
I want to make 3 points here. One is the nature of judging. Judges must see from near and judge from far. What do I mean by that? It means that when you are a judge, and I mean whether you are a judge of a carnival show, a musical competition, a judge of a court, who gets the best seat in the house? The judge. The judge must be able to see what's happening. A judge in a courtroom must not only see with their eyes what's happening, but they must be attuned to the society from which the dispute springs. Ideally, they should be immersed in that society, or at least near enough to appreciate the norms and the mores and all of the intangibles that guide that society forward. The judge must also be able to judge from far. That is to say that although you are close to the action, although you are immersed in the society, you must be objective. You must be distant in that sense. You must be impartial. A judge from Mars, a judge from Australia, a judge from Europe, a judge from England would not be able to fully understand, assess, and give a proper judgment on issues that require discretion that come out of a Caribbean country as a judge from the Caribbean country can. Because the judge from the Caribbean country is in the region. Secondly, to my mind, there is a certain accountability deficit whenever a judge is making decisions for a polity, for a society of which the judge is not a part. Because it means then that you do not experience for yourself the consequences of the decisions that you make. The third point I want to make is this. I've read a lot of the press in Jamaica on the CCJ and on this debate. And what I'm not seeing a lot of is the fact that the CCJ is not a foreign court as far as Jamaica is concerned. The CCJ is Jamaica's court. It is as much Jamaica's court as it is Guyana's or Dominica's. It's like this. The countries of CARICOM decided, English-speaking Caribbean, but our old CARICOM. We have a vehicle that we have been using for centuries. We don't think that, put it in a positive way, we think that we need a new vehicle. So we decide to acquire a new vehicle. $100 million that vehicle costs. Jamaica paid $27 million towards it. The vehicle was put into operation. Brand new tires, good transmission, nice steering. Jamaica is not riding in it. Guyana is riding in it. Barbados is riding in it. St. Lucia is riding in it now. Dominica is riding in it. Belize is riding in it. Jamaica is not riding in it. They're holding it by the coattails because it also does the original jurisdiction matters. Why is that the case? This court is staffed in part by Jamaicans.
Yes.
There's a Jamaican judge here. The nationality that is second to Trinidad at the court staff is Jamaica. Jamaicans have dominated, and I use that not in a pejorative sense. Jamaicans have been the majority nationality on the body that selects the judges. There have been over 20 commissioners who have been Jamaicans, and we value their service. Currently, there are 4 of them. I highly value their service. So one needs to probe the question, how is it that Jamaica is looking at this vehicle? Other people are riding in it, and Jamaica is not in it. And that is one of the things which I'm hoping that would be expressed. Now, you're not obligated to ride in it, because, of course, that is a choice that you make.
Yes.
And it may be that your government and your people don't want to ride in that vehicle. But the fact is, you agreed to establish it. You agreed by treaty to ride in it. You have a treaty obligation to fulfill in that respect. And other people are riding it. And are they dissatisfied? Those countries that have decided to use the vehicle, what has been their experience? And that is one of the things, another of the things that I find that I'm not seeing enough of in this debate.
Yes.
Yeah.
Are Guyanese satisfied with the CCJ? What about Barbadians? Barbados is a very orderly society. They broke away from the Privy Council and began sending their appeals to us in 2005. Do they have any regrets about it? Have they found that, oh, they are buddies in that court and we regret going into that court? Has that been the case? I would suggest that that has not been the case. Not at all.
Do you have any numbers, Justice Saunders, that can assist with the listeners? So, for example, if I recall, a little bit of pushback from the University of the West Indies, Dr. Malcolm, where I believe he noted that only 8 cases were before Privy Council for Jamaicans last year.
Yes.
So when we look at Barbados, for example, do you have any percentage available to give an indication that when Barbados was utilizing the Privy Council, they had X matters before that court versus when they adopted the CCJ, there was X percentage of improvement in the number of matters that had advanced. Do you have any such data?
Barbados' appeals to the CCJ in a 10-year period that they were on CCJ compared to the previous 10 years,
Yes.
increased by over 300%.
Wow.
In 2022, I have the figures right in front of me.
Yes.
In 2022, we heard 6 cases from Barbados, but Barbados is has 1/10 of the population of Jamaica.
Yes.
Yes.
Jamaica has a population of about 2.8 million. Barbados has a population of about 200 and about almost 300,000. In 2023, up to this point, we have heard 9 cases from Barbados. So, by that metric alone, there's no comparison between the volume of cases that the CCJ has and those that are heard by those countries that still send their appeals to the Judicial Committee and the Privy Council.
Yes.
But that is not even the main thing in my respectful view.
Yes.
The main thing is, as I said, how effective is the Caribbean Court of Justice in fulfilling its work as a final court of appeal. If you found that the vehicle is not effective, it has tires that are flat, the steering isn't working, transmission isn't good, and that's fine. But it would be very helpful, I think, if a greater degree of study is done in relation to the track record of the court.
Yes.
This is a court where our judges are subject to a tremendous degree of accountability. First of all, we know how they're selected. When they are selected, there is a code of conduct and there are judicial discipline regulations that are on our website that tell the public if you have a complaint against a judge, if you think that a judge is going to be buddy-buddy with their colleagues that they went to school with, or that the judge is making decisions that are questionable, or that the judge's morals are such that they flout the code of conduct. On our website, we have regulations that tell the public how you can make a complaint against a judge. We have a harassment policy in the court. We have an annual report which summarizes the judicial and administrative work undertaken throughout the period. We just adopted the commission on which 5 Jamaican nationals are.
Yes.
Just adopted policy for staff. So if you have any kind of grievance, these are measures of accountability that ensure that with the independence that the court has, that there is a sufficient level of accountability that the judges can must demonstrate.
And just to put in context, Justice Saunders, this came to light again recently. Michael Hilton, King's Counsel, again Dr. Malcolm, others such as Bert Samuels, attorneys here in Jamaica, have sought to dispel that myth that somehow the body system that the public has asserted exist in the CCJ, and that we have no influence in terms of the selection of those who serve at the Privy Council. So I'm happy that you highlighted that, because that is one of the main challenges or criticism that have been unfounded, that have been brought to the public space. We're going to take the last break, Justice Saunders, and when we return, we're going to be asking you if you could explain how accessible that vehicle is. And I'm just carrying with that analogy that you have put forward, the roving court. What exactly does all of that mean for the average Jamaican citizen getting access to justice? And we're going to also pick up in terms of understanding the structure of the CCJ, how many justices sit, and how which country they represent from. So I know you mentioned how many Jamaicans sit on it, but how many do we have, and how exactly they're selected? So we take the break. Welcome back to Let's Start Justice. We are discussing the Caribbean Court of Justice with the Honorable Mr. Justice Adrian Saunders, the President of the CCJ. Before we went to the break, Justice Saunders, I was asking you firstly if you could just give a quick overview in terms of the structure of the CCJ, how many judges sit on it, and how that selection process itself takes place.
Sure. Okay, there are 7 judges on the court. There is 1 Jamaican, 2 Trinidadians, 1 judge from the Netherlands, 1 judge from Belize, and myself from St. Vincent and the Grenadines. The judges are selected by the Regional Judicial and Legal Services Commission, which, as I said, is a body comprised in the main of outstanding lawyers and jurists throughout the region. We have had on the Judicial and Legal Service Commission, for example, persons of the stature of Dr. Barnett, Dr. Lloyd Barnett, Professor Carnegie, Mr. Shirley Tyndall, Mr. Justice Dennis Morrison, Mr. Alvin McIntosh. Currently on the commission, we have Mrs. Jacqueline Samuels Brown, Honorable Justice Brian Sykes, Chief Justice, Madam Justice Hilary Phillips, and Mrs. Nadia Small Davis. So it's a body comprised of a broad base of persons within the region. When there is a vacancy, we advertise that vacancy. Persons apply, they have to submit their CVs and information about their experience. And the commission would interview them, make a short list, interview them, and based on their track record, based on their knowledge of them, because the Caribbean is not a very big space, relatively speaking. So some of them would have already been known, would have a track record, would have a body of work that could allow one to make an assessment. But the commission does it on a transparent, competitive, merit-based manner. And these are how the judicial selections are made. Our filing fees, we think very reasonable. If you were to pursue an appeal at the CCJ, you would pay at most $1,250 US. And that, I think, is very reasonable compared to, I don't know, other courts that you pay that smaller figure, quite frankly.
Yes.
And we have kept it deliberately low because we want to get the hard cases. We want to get cases from all walks of life. And because of that, we've dealt with a case, for example, Gibson and the Attorney General of Barbados. This was a case of a man who was charged with murder, and he complained that he wasn't getting a fair trial because the only evidence against him was that the deceased allegedly that he had a bruise on his arm that could only have been made by the deceased, that it was a bite mark from the deceased. That bite mark evidence is very controversial evidence, and you need an expert, what they call a forensic odontologist,
Yes.
to be able to assess that kind of evidence. And he said, well, I'm too poor to have forensic odontologists. And so the question was whether the state was required to afford him the services of a forensic odontologist. And the court held that, well, you have to allow him to get a forensic odontologist. That is the only evidence that you have, or otherwise it would not be fair to bring the case against him. And that decided that case. You know, we have dealt with other cases where, for example, Ventos, where a CARICOM citizen in Barbados, under the laws, CARICOM citizens, if they're resident for a particular length of time in a CARICOM country, they ought to be entitled to vote, to be on the voters list. He was complaining that his name had not been placed on the voters list. And I remember that case very well because it was an appeal that came in on a Friday. And because the elections were the following week, we dealt with it on the Sunday. We dealt with the lawyers appearing at the parties appearing in Barbados, and we dealt with it virtually. The CCJ was the first court in the region, for the region, to engage in virtual hearings.
Yes.
We were the first court to engage in electronic filing. These are not things that I make up. These are facts that can
But
be
Justice
checked.
Sanders, if you may, and again, I'm not asking you to speak directly to Lord Reed's letter, but he did indicate, for example, that the Privy Council does have similar provisions. But for purposes of our listeners, I remember that was also countered and challenged by attorneys here to indicate that though Privy Council has that provision, you still have to get an attorney, a solicitor in the UK. So I'm happy that you mentioned it because that is the difference. You do have that virtual platform, but the attorney that we have within our region is quite sufficient, where there is not that need to secure another from the United Kingdom when you compare it to the Privy Council.
I'll tell you something, Miguel. One of the great advantages of the court is that we do some of our hearings in the country from which the appeal comes.
Yes.
This year alone, we heard appeals. We went to Guyana. We heard appeals in Guyana. We also went to Barbados. We heard appeals from Barbados. When Shanique Mary had her case, she had witnesses who were Jamaican. I remember there was a Jamaican doctor. The court went to Jamaica and heard his evidence, so that the court tries to make itself as accessible as resources and circumstances might allow. We don't just sit in Trinidad if it is possible to meet the litigant where the litigant is. Of course, it's expensive, but sometimes you can't put a cost on justice. And so for the Shanique Mary case in particular, we had hearings in Jamaica,
Yes.
in Barbados, where the incident occurred, where we went through and through the airport so that she could point out certain things to us, and the final submissions were in Trinidad.
Thank you so much. Another question, Justice Sanders. You mentioned that $100 million. And I remember some of the criticisms, again, being levied on social media, is the Privy Council has been around for a long period. What about the sustainability of the CCJ? Yes. What would be your quick statement to assure Jamaicans when you consider that $100 million trust fund that exists?
But let me say this. Every society has to support their court structure, because the court structure is an integral part of democratic governance.
Yes.
And to my mind, it is not a sufficient answer to say, well, if there is a court structure that you could get for free, that you must just use it because it is free. I think that does not suggest a very sort of keen and appropriate approach to governance.
Yes.
I think that you look at the court structure that is best for you and you support it as best you can. The $100 million was put into a trust fund so that it can keep rolling over. At some point, there has to be an injection in that fund because the amount which was initially envisaged did not take into account certain factors. But nevertheless, the court has been operating for over 18 years, and the trust fund is still at, I think, over $70 million. And to me, that was not only a very good approach to funding the court, because the countries that subscribed to the court had to repay those monies over a long period of time. All of them repaid those monies. It was an economic way of funding the court, and it was a way that ensured that the court retained its independence from the states that send their appeals to the court, so that you are not waiting cap in hand for a subvention each year, as the case may be. That funding mechanism is so highly regarded throughout the 2 weeks ago, the Court of the Andean Community were in touch with me precisely for the purpose of trying to explain to them how this thing works, because they would like implemented for their court in Ecuador, Quito, Ecuador. So it's a very innovative solution to funding the court, and it is one which I think is very, throughout the world, people are very impressed with.
Okay, great.
Thank you so much, Justice Saunders. I'll ask you for your final thought before we close out the show.
I think that the best way of informing the debate on the CCJ's appellate jurisdiction is to hear from those countries that have acceded.
Yes.
What has been their experience? Because, of course, I come here and say anything. But it would be important to hear from the lawyers, those who have been litigants, the governments of the various countries. When we go to Guyana, we are very well received.
Yes.
When we go to Barbados, we are very well received. As a matter of fact, some time ago, the same case that came up with the CARICOM citizen who wanted to vote, it was not a decision that pleased the then Prime Minister. And after the decision, he went on air and said some not so very nice things about the court. And I was blown away. I was absolutely astounded by the response that was in evidence from ordinary Barbadians. I never realized that the court was as highly regarded as was apparent. And those who know what happened next, elections and so on, know what happened next. But as I said, in the countries that send their appeals to us, the court is very highly regarded. And that is something which I think can be a source of comfort for those countries which are considering whether to subscribe to the appellate jurisdiction.
Great. Thank you so much, Justice Saunders. I can't tell you how much we appreciate your coming on. And I hope that we can have future discussions because, again, as we stated in our emails when we were seeking your audience, and as we stated at the start of this show, constitutional reform is an ongoing process in our country now. We're happy for it at JFJ. Yes. And I stated on behalf of the organization that JFJ stands in support of the CCJ being adopted by the country. So as a part of our public education drive, Justice Saunders, we will be scaling up and doing much more in 2024, and where feasible and appropriate, we hope that we can call on you again.
Absolutely, anytime. And I would ask your listeners to go on social media and get direct information about the court, from the court, and about those who know the court best.
Yes.
We have a very active social media presence. We have a website, and there's a lot of information from those sources that can help to inform one about what's happening with the CCJ. So thank you very much, and I certainly look forward to joining you again in the future as and when this is appropriate and necessary.
Thank you.
Thank you.
That was the Honorable Mr. Justice Adrian Saunders, President of the Caribbean Court of Justice, with us talking the Caribbean Court of Justice
Yes.
and just obviously some of the benefits of being with the CCJ, the economic benefits, just us advancing jurisprudence in terms of perhaps making some of those tough,
Decisions, looking
big
at
and bold steps.
having some jurisprudence dialogue
Absolutely.
that we have not been having. Yes.
And to put in context quickly for our listeners, we got permission to go a few minutes over. So for the listeners who are here with us, we'll be with you for just another 2 minutes. But just to put some things in context, we have a huge crime problem in the country.
Yes.
And obviously there are bigger issues at play, or other issues I should say. But we have a huge crime problem that is not only within the Jamaican landscape, Jade, but also if you listen to the regional conversations with the several prime ministers, Ralph Gonzalez from St. Vincent,
Yes.
Dr. Keith Rowley from Trinidad, and so on, the crime problems are quite similar. And we've been having conversations about what to do to address them. And the solutions are all the same. Let's impose death penalty. Let's get rid of our bail rights, and come with some strong bail act measures, mandatory minimums. And the question becomes, if we were with the CCJ, what would the CCJ say? Would the CCJ take the bold steps when they talk about savings law clause that has implications for abortion, death penalty, the sedition as you saw in Trinidad recently?
Yes.
What would the CCJ say? Would it take the bold step in saying, no, savings law clause, they're unconstitutional, and get rid of them? So it's food for thought.
It is, and just in my reading experience, yes, they would take the bold step. But we, yes, I do.
You're preempting the judges, eh?
Yeah, absolutely.
All right, but it was a good show. Thank you so much to our listeners. Next week will be our last show before we take a 1 month break.
Yes.
Yeah?
Yeah.
Do we have any winners for your trivia?
Yes, we do have a winner. It's Kimmy. This is your 3rd week winning.
Oh, consecutive?
So congratulations. You seem to be quite educated on certain issues here. But the question was, what was the year that the agreement for the CCJ was finalized? And the answer, the date, and the answer was July 23rd, 2003.
Yeah.
So you are the winner, and we'll reach out to you via Instagram. Thank you so much for joining us. I am Jade Williams, Policy and Advocacy Specialist.
And I'm Michael Jackson, Executive Director of Jamaicans for Justice. See you next week. And enjoy the festivity of this season with the Christmas carols and all of those niceties as we will be gaining weight during December. Yes. Bye.
Bye.